Okay, so we are now recording. Hello, everybody. My name is Brian Sanya Mondoh, and I'm happy to have all of you here today for the second Crypto Mondays Caribbean webinar. Today, we have a very exciting panel with us, and it's full of the OGs, I'd like to say. So we're going to start with Keir Finlow-Bates. Then we have Keniel Ledgister. We have Matt Green, Erika Knierim, Marina, Markezic, Racheal Muldoon, and Adella Toulon-Foerster. Now, we're going to start with a round of introductions, and then we'll pick up with today's order of events. So, Keir, if we start with you, then move to Keniel, then the order flows accordingly.
Okay. Well, I'm Keir Finlow-Bates. I have a PhD in mathematics and information engineering. I'm an inventor and researcher by trade, specializing in blockchain. I've been looking at blockchain since 2010 and full-time since 2015. And I'm really interested in anything to do with blockchain. So whether it's how the technology works or how it impacts society or how the law is dealing with it, all those kind of things are of interest to me. But I'm a layman at all these things. So sort of, a jack of all trades, master of none. But I'm working on mastering some things. So Keniel, I think it's you next.
Keniel, yeah.
Yes. Good afternoon, good evening, everyone. My name is Keniel Ledgister. I am the Attaché for Department of Treasury IRS Criminal Investigation. I currently reside and sit here in Bridgetown, Barbados, but I'm a regional attaché, meaning I cover a vast amount of area. I cover from Bermuda all the way down to Trinidad. I've been with the IRS for going on 20 years as a financial investigator or special agent as a federal agent for 20 years. I've been here in Bridgetown, Barbados as an attaché going on 3 years now of my 5-year assignment. Again, as I say, I cover the whole Caribbean. A lot of it's dealing with financial crimes, obviously money laundering, tax evasion, compliance, and everything related to crypto as well. I do cover 26 countries. It is best if I say the ones I don't cover, which are DR, Cuba, and Haiti. So that's covered by my partner in Panama. But anything in the financial crimes realm or compliance, I'm your guy. Pleasure to be here.
Thank you, Keniel. Matt?
Hi, everyone. My name is Matt Green. I am a partner at Lawrence Stevens. I am the head of blockchain digital assets and head of tech disputes. My role in the world of blockchain falls back to 2019, where I worked on a case we're going to talk about a bit later, which deals with crypto assets becoming property at law. And since then, pretty much my full-time job has been assisting victims recover their crypto assets of any kind against a variety of different perpetrators, including Lazarus in North Korea, which is obviously good fun. And it's mainly been against sort of persons unknown, decentralized entities. And I just want to sort of state very early on that making recoveries for crypto assets is not only doable, but more than doable. And it's my job, as well as others, to inform that it's actually a tried and tested formula now to help people who are victims of a fraud, a hack, a scam, whatever it may be, to recover those assets. And of course, that practice sits alongside other things, insolvency, matrimonial issues, where these types of assets need to be traced and recovered. So I'll tell you more about all of that a bit later. But thank you, Brian, for inviting me.
Thanks, Matt. Erika?
Hi, everyone. My name is Erika Knierim. I'm an attorney based in Chicago, Illinois. Formerly the regulatory attorney at Celsius during their bankruptcy. I left that company, obviously, and am now the head of emerging technology at a firm here in Chicago called Founders Law. And within that emerging technology, I work with blockchain, AI, quantum, Internet of Things, everything that's at the bleeding edge of the regulatory environment. And I help founders, everything from formation through about Series C, build a responsible company from the get-go and try to help them avoid the outcomes that we've seen in the blockchain space so far.
Thank you, Erika. Marina?
Hi everyone, my name is Marina and I'm a co-founder and a director of the European Crypto Initiative, which is a non-profit association based in Brussels. We do work with regulators, mostly on the markets and crypto assets regulation, but also anti-money laundering package, etc. Mostly with all the regulations, directives related to crypto assets. I have been in the space from 2017, where I have joined one of the first accelerators in the world, really focusing on blockchain, and where I was performing some basically legal and also business activities there.
Thank you, Marina. Racheal?
Hello, everyone, wherever you're joining us in the world. My name's Racheal Muldoon. I'm a barrister at Maitland Chambers in London. What is a barrister, you may ask? We have a strange legal system in the UK where we divide up solicitors and barristers, barristers being those with rights of audience to go to the highest courts in the land, wear the silly wig, which is not vegan, by the way. And meanwhile, solicitors pick up an awful lot of the hard work with clients directly, but also have some rights of audience. So that's my role. Why am I here? Because the past 7 years, my practice has been dominated, bridging the divide between law, both in England and Wales and across the world, and subject matter involving crypto assets, blockchain, DLT, all of that interacts with one another. So I've had the pleasure of acting in some pretty cool cases, acting for regulators the world over, including the SCB in the Bahamas in connection with FTX, as well as Cryptopia, MT-GOX, and many other fascinating cases. So thank you for inviting me on this esteemed panel.
Thank you, Racheal. Deld?
Hi, my name's Adella, and I am the founder of the Longlever Group. We are a consultancy, and we handle everything very janitorial services from soup to nuts. We have a sub called the Nakamoto Group, which is kind of like our skunkworks department, where we tinker with all the strange things. And I've worked in this industry since 2001 in the digital gold space, where I was very lucky to work with some of the key architects of some of the concepts used in this technology today. I've been in the crypto space since about 2010, and I was the former interim president at Local Bitcoins USA for years. I consult for law firms, I consult with regulators, again, all across the board, public and private sectors.
Thank you, Deld. Now, to members of the audience, thank you very much for joining us today. And we are about to start with our questions and discussions for the evening. Now, Keir, we want to start with you because so many people don't understand what blockchain or Web3 technology is and its alleged transformative attributes. So would you want to take us through a nice, deep analysis of what this is and where the world is heading to in terms of this?
Right. Well, not a difficult challenge there, Brian. The problem you have when you ask people what is blockchain is it's such an early technology that people default to explaining how the technology works. And they start talking about immutable ledgers and peer-to-peer networks and things like that. And the problem there is that really, to most people, that's not interesting. What they care about is, well, what can it do that other stuff out there doesn't already do? And I think it's taken years for us to really kind of put it into words in a way that makes sense. But it boils down to ownership and censorship resistance. So if you look at the way the internet works at the moment, and you look at the way banking systems work at the moment, as a user of the internet or a client of a bank, you are beholden to the company whose website you're visiting or the bank that you're using. You don't have much control. And what blockchain allows us to do is build a data storage and retrieval system where there's no one single entity in charge. And we use incentivization to make sure that it keeps churning along and obeys the basic set of rules that make it work. And the upshot of that is that if you want to conduct a transaction on the system, or if you own something on the system, then other people can't stop you. So compared to, say, having a Facebook account, Facebook can cancel your account. If you have a bank account and you want to buy some goods and your bank decides it doesn't like that, for example, let's say you want to buy crypto with your money, your bank may say, no, we don't approve of those kind of transactions, and they censor them. With blockchain, that censorship is gone. You control your identity on the blockchain because you can create your own blockchain addresses. And when you own digital assets on the blockchain, there's that record for everyone to see that you own them and you're the person in control. So in a sense, fundamentally, it's a new kind of ownership. I mean, ownership is a concept that's been built over centuries, and there's a lot of stuff in the law about it. When it comes to blockchain, there's some very practical stuff there, that you own your digital assets because you have the key. And really, the only way someone can force you to transfer them would be to actually take you hostage and threaten you. There's not anybody outside who can step in and say, I have the authority to take these off you. So that's the kind of, well, that's my attempt at explaining blockchain anyway. And then I think you also wanted an explanation of Web3. Is that right, Brian?
Yeah, so basically the terms are kind of used interchangeably, but I know the blockchain is part of Web3, and there's like other ledgers like DLTs. So
right,
a DLT, a blockchain is a blockchain, a DLT.
Yeah, well, I think blockchain is kind of a building block for Web3, right? The idea with Web3 is an evolution from what we're all familiar with now, Web 2, which is where you have websites that are built from information in databases, and if you log on to them, you can submit data to those websites, and then that data gets shown to other people if the owner of the website chooses to do so. So we're thinking of things like social media here, where you can post posts and then other people can read them. But of course, if the website owner decides they don't like their post or that post, or they don't like you, then they can block it. And again, there's nothing you can do about it. And we see all the time on social media that a platform has a particular political view, and if you say something against it, you may find yourself blocked. There's been tensions in the Middle East, for example, that have been very polarizing, and some platforms have decided they fall very much into one camp rather than the other, and actually block posts from people who are posting on the other side. So that's Web 2. With Web 3, you take out the database that the company controls and you put in its place a blockchain. Now you have a website where the interface looks familiar to everybody because you use a browser and you visit a web page and there are links and things like that. But now the data isn't being stored in a database that is controlled by Twitter, or sorry, X as they're now called. I'll learn it eventually, or Facebook or LinkedIn. Instead, it's a database that is kind of a free-for-all. And this comes with some benefits. It also, of course, comes with some downsides, because whenever you don't have somebody monitoring or moderating, you do end up with a bit of chaos. But on the other hand, it gives people who maybe are in oppressive regimes a way of being able to interact that can't be censored, unless the people are actually physically rounded up, of course. There's always that option. So Web3 is kind of built on top of blockchain. DLT was the third thing you mentioned. That is, I've always found that to be a term that sort of corporations and financial institutions seem to like, because there was this period where they didn't really want to be seen to be involved with things like Bitcoin and blockchain. And back in 2017, if you were in banking, for example, it'd be embarrassing to be talking about Bitcoin. We're seeing some radical shifts recently with politicians and bankers actually turning 180 degrees on previous statements they've made and saying that actually now they're all for Bitcoin. Just a year or two ago, the same people were saying that it was terrible stuff and it should be banned. How times change. So DLTs was a term that was used to describe decentralized ledger technology. And to be honest, when I see people talking about DLTs, it immediately says they're corporate. And often it's kind of like they're trying to come up with blockchain light to satisfy the existing incumbent institutions and not upset them too much. But that's my cynical take on that.
Thanks, Keir. So, Keir, before we move to Marina, could the topic today is achieving trust and transparency, rather, because they're always coming together. So, achieving trust and security. So, how can we achieve these two attributes? Because they kind of, they're touted as attributes to this technology. So, how are we able to achieve this when you have issues like, garbage in, garbage out? Like how do we control such phenomena, and how would you apply it in a Caribbean or any developing country for this in terms of application?
Yeah. Who was that directed at?
Sorry, did you get my question, or you got broke the network?
Oh, I didn't know you mentioned Erika, so I didn't know if the question.
No,
was...
I said Keir.
Oh, right, okay.
Yeah.
Well, I mean, you make a good point about garbage in, garbage out, which is there used to be this idea that if you put it on the blockchain, it would be true. But the blockchain isn't a machine that magically turns anything that is loaded onto it into truth. I can post a text string on the Bitcoin blockchain saying that, I'm a space alien. Doesn't make me a space alien. However, what blockchains do have is a set of protocols that say that particular transactions have to take a particular format. So it's very well defined and very locked down, very deterministic. And that's useful for particularly for things like finance, where the whole idea of accountancy and auditing is to make sure that the numbers add up and the books are correct. And with a blockchain, you kind of have an accounting ledger where everything adds up, because it's all done because are very strict and very particular. And actually, it's when you start understanding the codes, it's not the code, it's not that complicated, but it's very, very significant, because accounting is very significant. I mean, double entry bookkeeping, which was Pacioli came up with in 1494, and a couple of other people. So it's an old technology, over 500 years old, was revolutionary for allowing us to move forward. Various, industrial revolution, agricultural revolution, things like that, without accounting to keep track of who owned what and who had what debts and stuff. It just would have been impossible to coordinate those things. And blockchain allows that to a much, much deeper level. In particular, one of the interesting things about most blockchains is that the ledger is there for anybody to look at. And that, again, is very, very unusual from an accounting and from a company's perspective, because most of the time, entities are very secretive about their accounts. They only reveal them when they have to, typically to the authorities, the tax offices and stuff like that. They don't generally just post them up for anybody to see. And so with the blockchain, I may not know who Bitcoin has been transferred to, but I can see which address to which address it's gone. And as criminals have been discovering, it's not actually a very good network for money laundering, because it just takes one address to be identified with the person, and then through forensics, you can start investigating, well, who are the other people? There's this, the parallel I have is that in the UK in the 90s, the police wasn't allowed to wiretap without a judge's permission. But what they could do is they could get hold of which numbers were being called by members of what they suspected was a criminal gang, and they could build a web of kind of, well, these numbers call these numbers and these call this, and then they could actually build the structure of the organization without knowing the individual people. And then once they'd interviewed one or two people, the whole network became exposed. And the same thing is true with Bitcoin, for example, in that you have all these addresses, which are kind of like phone numbers in a way, you don't know who they belong to, but it all unravels when you start digging deeper. And there's a whole industry for doing that. So when it comes to transparency, blockchains like Bitcoin actually set a really good example for how you can make all this stuff available for people to investigate and to hold people publicly accountable. It's very hard to hide crypto assets, surprisingly enough.
Thank you, Keir. So, Marina, before we get to Marina, anybody want to piggyback on what Keir has said? Anybody in the panel?
I don't know if I want to piggyback, but I did want to take a small note about the DLT versus blockchain, because when we are working on sort of the front lines in founder world, when we have to sell some of those ideas to VCs, unfortunately, very much to your point, the VCs have been very spooked after FTX and Celsius, and therefore won't touch anything with crypto in the name with the 10-foot pole. And so what we've really been trying to talk to our founders about has been how to focus more on the solution that you're solving for. And DLT can be a little acronym that sits in your pitch deck, but truly there's a shift fundamentally in how companies are actually sort of shaping their ideas. And it's much less focused on, I have a crypto company or I have a DLT company. It's, here's my solution to the problem, and this is the software I'm using, but the software is not really all that important. And so I just wanted to make that note that although yes, it is driven by a lot of institutional buy into DLT and antagonism against crypto, there are a lot of companies that are still doing crypto solutions, but unfortunately they're sort of being forced in this environment to call it DLT because the VC money just isn't there.
Yeah, well, that kind of proves my point, doesn't it? I mean, there's very distinctive communities, because now you have a whole bunch of people who've made a lot of money off cryptocurrencies going up dramatically in value, and they don't really care about, you know, the Citibanks or the IBMs or the traditional VCs. They're kind of going off and doing themselves, and so if you were to talk to them about DLTs, then they would be brushing you off. It's almost like there's two camps.
Thank you. Keniel?
Yes, and to go back a little bit to what Keir was saying about transparency, just jumping a little bit here, but focusing on the Caribbean specifically, I know one of the biggest concerns as I travel and interact with different investigators, financial intelligence units, the attorney general, that transparency comes up a lot. And just the fact that we can leverage a technology of such, I think it'll be ideal for, in theory, a lot of these governments to, whether it's blockchain or Web3 or even just utilization of crypto networks out here. I think it's ideal to lend itself or hope that we could utilize cryptocurrency to watch how government is spending their money, watch how contracts are being paid, because you always hear the story of, well, the Caribbean is corrupt, that's why nobody wants to go there to do business. So essentially, I think this is an option on the table to help them essentially refute that, or essentially better or strengthen their ability to avoid any type of corruption. And that's just not in the Caribbean. You hear it throughout all of Africa. I mean, it happens in the bigger power, the US, EU, UK as well, but populations are bigger. There's so much more money moving. Define, in their theory, define corruption at that point. But the Caribbean is you have so much small islands. There's way more scrutiny of it, because it's sometimes a little blatant and you can see it. But I believe with these technologies, you do have the opportunity to present to the Caribbean an opportunity for investors to have a little bit more confidence in the systems, in theory, though.
Thanks, Keniel. Now, Marina, we're coming to you. Do you want to explain to us how the EU, in particular, the MiCA legislation, is trying to, bring harmony between the technology and consumer protection and, travel rule and all the things in terms of legislation? How does that work? And could you extend that application to the Caribbean world? Because most people right now just say referencing MiCA.
Yeah, absolutely. I'm happy to. So basically, for the last 4 years, we've been following the whole negotiation process when it comes to the markets in crypto assets regulation. But just to be clear, not as a regulator, but as an advocacy group that was representing the industry and basically checking and discussing, sharing information with the regulators whenever different ideas came up when it comes to the markets in crypto assets regulation. So the first draft, as you all probably know, was written in 2018, I think very early on within the commission, but it was published 4 years ago, 2020. And during that time, the whole draft changed a lot. But what we have right now is the final version, which basically regulates the issuance of crypto assets and also the crypto asset service providers. The issuance of crypto assets is very interesting because in a way, I would say it's very light touch regulation. In a sense, there is a white paper that needs to be written and of course notified and sent to the national competent authority. But at the same time, there is no obligation for the national competent authority to get back or review or check or basically in a way for the project that is issuing that token to wait for the regulator to respond. So the notification is good enough, but the information that is written in the white paper, I think it's pretty interesting because right now we have some sort of information that needs to be communicated to the users, potential buyers of the tokens. And I think in this case, it's very important to basically acknowledge all the information that is shared when it comes to consumer protection. So in this case, we want to make it a little bit more transparent than it was before. And I would also point out that with the MiCA regulation, in the first time over a really, really long time, at least in Europe, we have certain terminology that was used in the ecosystem that is now becoming a legal term. So the white paper was something that we have used before as something maybe alluding more to kind of a business idea or a kind of technical paper. But right now we have this white paper that has a legal term and has a very specific information that needs to be included. For example, one very interesting is the energy consumption of the whole technology and of the tokens that are issued within MiCA. So that's going to be pretty interesting because I have not seen yet any sort of similar requirements globally. So there are already service providers that are looking into that, but we also know that this is really, really hard to in a way calculate. So we'll see, this practical challenges going forward. And the other part is basically regulating crypto as a service providers. Most of the biggest companies that you know that are providing services within this industry, like exchanges, custodians, etc. But it is also regulating any kind of advice that anyone is giving related to crypto assets. So that's also pretty interesting when it comes to, for example, financial advice on how to invest in crypto assets. And for those crypto asset service providers, there's a lot of obligations that they need to follow in terms of exchange of crypto assets, reserves. They would need to have, of course, a license when it comes to MiCA. And in this case, again, a lot of transparency, a lot of information, a lot of requirements to basically share, disclose their information. And at the same time, they will have periodic disclosures and basically some type of reports that they would need to convey to the national competent authority. So how does it work in practice? As you know, we have 27 member states at the moment in the EU, but also additional three countries that are in the economic zone. So altogether we have 30 different national competent authorities, and those are really the ones that have power over the supervision of MiCA in each member state specifically. So in theory, we could have 30 different interpretations of some of the terms that we have currently in MiCA. And that we'll see how it will go in the next few months. But the idea of MiCA really is that it is a regulation. It will be implemented at the same time in all the member states. It will be also in a way we will have the same draft, the same law being implemented. The only difference that we have is the time frame. Certain member states can, for example, choose for MiCA to be implemented at the beginning of the year 2025. Certain can have a period that is longer, up to 18 months. Until MiCA is implemented and applicable in that member state. So those are the differences, but in theory, anyone that gets a license in one member state should be able to passport this license, and that means that they will be able to offer their services or offer their crypto assets in basically the whole European Union. And that was also one of the goals of MiCA, besides also creating a safe legal framework for consumer protection, as you mentioned. But also what was very interesting is that the big part of MiCA is really regulating stablecoins. And this is where MiCA is, I would say, also pretty strict. It alludes and goes back to some institutions that we have in the past, the e-money directive. And right now we have, following that, two types of stablecoins. One is the e-money token and one is the asset reference token. The e-money token is the one where the value is linked to one fiat currency, for example, USDC, and the asset reference token is where the value is linked to more different assets. It can be fiat or it can be crypto assets as well. So that is pretty, I would say, important, because within regulating stablecoins, this is also where the European Union wanted to create a stable financial ecosystem in the European Union. And the very, very recent, I think this was really the last part that was added to MiCA before being finalized, was a limitation on how much stablecoins that are non-euro denominated could be used for payments in the European Union. So in a way to avoid stablecoins that are not backed by euros to be widely used in the EU when it comes to payment. And if I think about, the other parts of the world compared to what the EU has done right now, I think it's a really good opportunity to basically look into MiCA and look into the parts that in a way are good and that maybe could be in a way copied somehow if anyone is looking into a new regulation. And then also trying to learn from the things that are not optimal and could be, done better in a sense. We will learn more over the time. It will be applicable only in 2025, so beginning of the year for certain countries, as I mentioned, and we will learn over time how it will look like. But I'm looking into also the international organizations, international regulators, IOSCO and BIS, FSB, all those in a way international organizations are looking into and promoting in a way the regulation of stablecoins globally. So I think that could be also very interesting for the Caribbean area to look into, okay, how to regulate stablecoins. It seems that this is really the first thing that is in mind when it comes to regulating crypto assets in general. Not that much the utility tokens that we knew before, but really the stablecoins as well. And I'll just add with the last part, which I think is really the most important thing that we have learned through MiCA and that we have seen in MiCA, is that the EU regulator and the EU countries, everyone involved, the Parliament, the institution, and the Council, they decided collectively that there is another type of assets that we never knew before, that is a completely new type of asset that is called crypto assets. And it's not a financial instrument, it's not a security, it's not something that we knew before, but it's a new group of asset. And this new group of asset, in a way, needed a new regulation, and that's why we have MiCA. So there's also very, I would say, detailed guidance for us to understand better when an asset is a crypto asset versus when it is a financial instrument.
Thank you very much, Marina. Now, Keniel and Adella, in terms of the application of MiCA and the external world view of MiCA, how do you see it applying in terms of the local Caribbean laws, and how are the governments, and you guys can take this in turn, so how are the Caribbean governments receiving this, and does it vary from country to country, or is there a joint CARICOM approach to policy?
So I would say the only commonality that there is that there is a curiosity in the region, and that curiosity lives on a spectrum. And from that perspective, it's really interesting because we have a really diverse cultural and governance landscape where every nation within that region operates within its own unique socio-political context. I mean, we have countries of different languages. We have English, French countries, Creole countries, Dutch countries, Spanish, so you try to, from the outside, it may look like one region, and it kind of is geographically, but culturally, it's just a different sort of scenario. And what I found is that the legislative landscape is pretty interesting. So we have a couple jurisdictions who have adopted a model that was given by an international organization and passed into law. And then we have other islands who've done their own had their own unique take on it, like the Bahamas, for example, and Bermuda, and Caymans, and so on. But we also have a couple of different central banks down here. And that just makes it, again, very interesting when you have a currency board trying to maintain a peg, where the costs are passed on to us as the end user. And then we're, on the other hand, trying to grapple with something that is, I don't believe, very intricately understood here, and how its application could even change the landscape. Now, we have seen a few CBDCs. We have seen the Bahamian dollar, the sand dollar. We have the Dcash from the Eastern Central Caribbean Bank that was launched, and I believe it is still in the pilot phase. But again, is that really like the right use? Like, should a central bank really have that much of an ability to look and surveil the use of your finances? I don't know. Maybe it's just a philosophical question here, but let me just say that there's no way that anything MiCA could not affect us, because everything that happens in the bigger countries, especially the ones that we maintain correspondent banking relationships with, just domino effect down to us in terms of increased compliance costs levied on us, sanctions also levied on us, because we're seen as the high risk clients and customers. And I don't know, Keniel, if you want to take it from there.
Of course, 100% agree with you.
Keniel, just before you proceed with that, don't forget your train of thought. There's something Keir mentioned in our prep session, and it was the difficulty or the the remoteness of the legislation, the MiCA legislation in particular. Like, is it so far from reality? So if experts like Keir and the experience in the industry feel like it's really remote and out of place, so how will such a regulation play in regions that don't even have that legislation in the first place?
Well,
you reconcile these things.
I mean, that raises something which is, Marina mentioned that MiCA was a light touch, and it does actually say in the text that the aim is not to impose an undue burden. But the document itself is nearly 100,000 words long, which makes it almost as long as Harry Potter and the Prisoner of Azkaban. And I've had numerous discussions with friends who are lawyers in this space, where I've invented tokens that they couldn't decide whether they were an art or not, whether they fell under MiCA or not. The issue that the regulators face is that we've suddenly got, it's like we were building with just one type of Lego block. And now with smart contracts and blockchain, we've got a whole box of different shaped blocks, and you can stick them together in unexpected ways. And it becomes very difficult to classify new innovative ideas under that legislation. And I've read MiCA I think I'm up to 6 reads now, and I've decided I'm not going to read it again. And I kind of end up with a feeling of, well, I can't be bothered. If I'm going to do anything, I'll set up a company outside of the EU rather than try and do it from Finland, because it looks like an immense amount of legal consultancy is going to be required. It's going to cost a lot of money. And there are other places which are a lot more relaxed about it, where I can go and launch from instead.
Thanks, Keir. Keniel, you want to assist? You want to?
Yes.
Yeah.
Actually, I'll start with the easy one first about I was gonna say Micah initially before, but Mika being the other one on the other side of the world here. Um, it's in this world currently, it is great because it's foundation. It's good to stand for something at this point and have everybody else build off of it. I think that's probably what's the misunderstanding when you see all these legislations that are being drafted, is there's just a misconception that this is the end all be all, whereas we need to just have a foundation, especially as technology's changing. I don't want to compare it to it, but this is the only thing I could compare this current crypto Web3 to is the dot-com boom. I think people in the back of their head have this fear that everything's going to self-implode. Whereas my mindset, I hope everyone, I'm pretty sure we're all of like mine, but we just need to embrace it and figure out how to integrate it into society. Specifically for the Caribbean, one of the issues, to comment back on what Adele was saying about I don't think the Caribbean is ready. It can get there. The main issue in our region, and we're getting towards it, is that some of the basic things are still like paper form. You know, it's not like your modern countries where things are super automated, things are a little bit more efficient. You still have to deal with if you want to obtain any report or have anything done here, 9 out of 10, if, for example, Barbados is a little bit more advanced, but in general, a lot of things are still paper-based. So that creates a lot of inefficiencies. So if you do, for example, you need to renew your driver's license, it just came online recently, as in less than a year ago. And this still has its other issues, but maybe a big jump to this technology could kind of essentially force this efficiency. But in general, I do feel the Caribbean, just to wrap it up, is not ready. There is a general fear because of the technology and all the mishaps of the other FTXs, Mt. Gox, and name them. There's a genuine fear. So they are sitting back, in my humble opinion, waiting for the bigger countries, the EU, the US specifically, UK, to make these decisions, create these laws, and have a better foundation before they react.
Thanks, Keniel.
So
Now,
I'd like to just add something for 2 seconds, and I want to go back to the word that you just used, foundation, which also happens to be one of my favorite novels by Asimov. Is it Heinlein? Heinlein, Asimov. So foundation, we simply don't have the foundation, and we've had over a decade to understand the subject matter, and what we have now is a little bit, I think, dangerous. We're walking into a bit of dangerous territory, because now we've launched these crypto asset business acts in several countries, and the regulators who are regulating this subject matter do not understand it. I was very fortunate to be a part of a redrafting period and comments period from one of the acts down here, from one of the bills. And I was a bit shocked at how much we're still grappling with very basic concepts, even given the amount of time. And I think we're coming to a point where we can no longer use it as a credible excuse. So yeah, we need more foundation here. The regulators need more foundation here.
thanks, Dels.
I think you're right. I mean, as somebody who is actively involved in inventing new blockchain concepts, I mean, you look at a line in the regulation where it says that this doesn't cover non-transferable assets. And my first thought is, okay, so can I make a token that cannot be transferred at this point in time? So now it's not covered by MiCA. But what if at some point in the future it can then be transferred? Then it will be. So I could defer some of the regulation. Another one I had was a stable coin that was a basket of other stable coins. which I think, Marina, you'd agree with me, would be an art because it's not referencing a single currency. But again, looking through the stuff, I wasn't even convinced that it would actually fall under the art regulation. And I couldn't get three guys to agree. Two said, no, it would be an art, and one guy said it wouldn't. And the guy who said it wasn't was somebody who was actually involved in the consultancy for MiCA. So I'm just sort of stuck here where whenever you come up with these things can get pretty unusual compared to standard financial instruments or money. Money looks really simple compared to some of the stuff that you can do with tokens. And we're going to see an explosion of tokens that are doing all sorts of unusual things where you kind of go, well, and I look at the regulation and I feel it's a bit like that rule they had where they wanted a man with a red flag to walk in front of a car to, the sort of first automobile regulation, where it's all about slowing it down rather than trying to understand these things can go quickly. We're going to need health and safety legislation. We're going to have to improve our road infrastructure. We're going to have to learn how to deal with the fact that one day the roads are going to be full of very fast vehicles. And just saying, here's 98,826 words that, in my opinion, equate to a man with a red flag in front of a car, it's not going to cut it. So that's good for the Caribbean, because if they're holding off, they have a chance of kind of leapfrogging those mistakes and actually coming up with legislation in the future that, from my perspective, will make a lot more sense, because it's always much harder to get rid of legislation than it is to pass it for some reason.
Thank you, Keir. Marina, your hand was raised rather.
Yeah, just very briefly, one specific part that is pretty interesting in MiCA is the part where we define crypto assets. And crypto assets are defined in a way where we have specific types like the utility tokens, and then we have a specific type like stable coins that are basically e-money tokens and asset reference tokens. But other crypto assets, it's a group that is basically made for including any new type of crypto assets that might be invented even in the future. So the idea was really, okay, we know that this industry is changing so quickly. We need to have some terms that are so broad that we want them to be included, but we cannot name them right now because they might be invented just in 1 or 2 years. So that is something that the legislator has been thinking about while drafting MiCA as well.
So does that mean we're going to get another 100,000 words every couple of years?
Yes,
we're starting to head towards in search, the research is perdu. At the end.
Exactly. I mean, there are reviews of MiCA, and you have heard about the MiCA 2, etc. But there's going to be continuous reviews of MiCA, and we are already talking to some of the basically institutions within the EU about certain things and activities that have not been regulated under MiCA. It might be included this year, next year, in 3 years, but I think we will be adding to what we have right now.
Right. Because you see, if I look at something, I mean, people in crypto hate it, but I think it's a brilliant, it was a judge, I think, who came up with the Howey test from the US. The SEC has this, because they were trying to determine whether some citrus grower consortium was actually trying to sneak in selling securities by the back door. And the Howey test is I think it's like 50 words long to describe it. And it's actually a surprisingly powerful test to be able to determine whether something is a security or not. Now, I'd love to see something like that for crypto, where you can actually put it on a single page. And this is what bugs me about this stuff, is when you look at older documentation, it's surprisingly short. And I just see this tendency of everything getting longer and longer. And there's just, I mean, there's, the amount of repetition in MiCA. It doesn't help us if people who are concerned about this stuff can't understand it, because it's just so long that by the time you get to the end, you've forgotten what was going on in the middle or the beginning. And I mean, it's great for law firms because they get the opportunity to publish their little articles in their blogs explaining this paragraph or that paragraph. But that's my big concern. I mean, I'm all for regulation, but I don't look at MiCA and say, oh, this is going to protect the consumer, the EU citizen, and I don't think it helps the industry. Ultimately, it's just verbiage. But that's my take on it anyway. And I'd really like to see places like the Caribbean sidestep that and actually have something that is not going to fill up libraries.
Thanks, Keir. Now we're going to move to Erika, Matt, and Racheal. But before we move to them to discuss asset recovery and the definition of what crypto assets are and the risks that consumers face in that landscape, I just want to find out from Keniel and Adella, from basically what you're saying, if the Caribbean is not quite ready, as you allege, does it just mean the Caribbean is good for jurisdiction shopping in terms of incorporations, but it's not good for the locals to experience or explore these products? And Racheal, you've been to Barbados, and I'm sure you've had some interactions with the locals during your trip. So, because I'm really at a loss here, like all I'm hearing is the Caribbean is not ready. So, and my experience with the Caribbean people is they like foreign. So they have to wait for it to happen abroad first, then it can happen locally. So are we just good for incorporation and not for interaction with the real thing on the ground?
Again, when you say we, it's a little bit misleading in a sense. It's like saying the US is really good for politics now, and that's probably not the case, right? So we have some islands that are really, really great for different kinds of financial services, as you know, IBCs and certain ones, very good foundations, trusts, etc., etc. And they have their strengths there, reinsurance in Bermuda, for example, and so on and so forth. We are very, very inviting. We're very accepting, but we simply do not have the foundation, the ability to take it on in a way that we probably should, because the bigger jurisdictions haven't really figured it out yet. I mean, look at the SEC, look at FinCEN, which they seem to be a bit more organized than the SEC is. They're just a giant mess. Look at MICA. It's, wow, it's not really on the summer reads, top 10. So, what are we supposed to do? Because we kind of wait, and this is me admitting something a bit embarrassing, is that we wait for you guys to figure it out, and then we're like, well, all right, well, that looks good, so let's just go ahead and jump in. That's fine. Like it's safe now, it's good, so we can go ahead. So I think that's again, a bit philosophical, but I think therein sort of lies the crux.
If I might be able to jump in and comment on this, because I think we're really seeing a question about the move of regulation, and I think what that can't be separated from the movement of politics and the movement towards the far right that we're seeing in Europe, and sort of anti-regulation and deregulation. I think we can't talk about this today without talking about Trump being the keynote speaker at Bitcoin 2024 the other evening, and saying that we're going to be the number one Bitcoin country in the world. We're going to create a Bitcoin reserve. I think that really speaks to a certain subsect of the Bitcoin community that believes in regulatory arbitrage. And when we talk about regulatory arbitrage, you look at MiCA. If MiCA is overly cumbersome, these companies are going to go elsewhere. And as someone on the front lines with founders, I have that conversation often. These frontline founders are usually fairly young. They don't have families. They're not anchored to any particular country. And they ask me, what's the best country to actually found my company? And they are willing to uproot and move to a place that gives them funding and a regulatory sandbox to do the things that they think are the future of this industry. I am not going to judge that one way or another. It's just something that we all need to be aware of. And there's that moment of, if the Caribbean is ready to take on that challenge and can really, in real time, accommodate these companies and allow for them to build these ecosystems, the rest of us can potentially learn. Because quite frankly, with the fall of Chevron deference, we're going to see a really different future in terms of the regulatory ecosystems. We're talking about the SEC and the CFTC, but with Chevron falling, those agencies have been gutted of power to begin with. There's some beliefs that crypto can still be regulated post Loper Bright, but that means that Congress has to pass laws clearly defining those regulations. And let's be real, Congress can't make an agreement on whether oranges are orange at this point. We've completely shut down, and that's where the Supreme Court sort of understood that by gutting Chevron deference, they would bring all regulation to a stop, because in order to get regulation passed, you have to actually account for every possible scenario, which at the forefront in emerging technology is not possible. And so the bright side of that is, in the event that, again, I'm not going to bring up my own political leanings, but in the event that Trump does get elected, that's going to speak really well and of the crypto industry. I think that there's going to be a lot of opportunity in the United States and a lot of collaboration and cooperation with countries that are going to create ecosystems that allow for some of this technology to be brought forth. But until the election, I really, from an American perspective, I think regulatory arbitrage at the very end of the day is going to be the future.
In response to your question,
Thanks,
Brian.
Erika. Yeah, Racheal. Yeah.
If I may, and
Yes.
you know me, Brian, I do like to be controversial now and again. I won't disclose my political leanings because you certainly don't want to hear it. But let's take a step back. Legislative frameworks are only as good as two things. Firstly, the contribution of experts from industry, round those tables, engaging in those discussions, giving their industry knowledge as to the technology, as to transactional particulars, as to how the market is developing. That's the first element. And the second aspect that really makes up a successful legal framework of any description is the extent to which they're listened to. And that is then implemented in that legal framework. Now, whether we're talking about AI or centralized finance, CeFi or DeFi, wherever we find ourselves, those two fundamentals are fundamental. And so let's look at things. I've interacted very closely with the Caribbean as a region for the past year in particular, and also the past 2 years since the collapse of FTX, which I won't be exploring in any detail given my instructions. But what I will say is this: I think the Caribbean is at the cutting edge. Let's be more generous about what's happening in the Caribbean, I should say. You've had the DARE Act since, 2020 in the Bahamas, cutting edge. Let's face it, it facilitated one thing that hasn't been done before, that I'm very proud to have played a minuscule part in, which is the Securities Commission of the Bahamas becoming the world's largest trustee of crypto assets ever. And as a result, consumers hopefully being protected. But I can't speak to that further. That hasn't happened in the UK. That hasn't happened in Singapore or the DIFC, or certainly not the US. So that's just but one example of where a considered, and no legislative framework is perfect, but a considered legal framework has enabled, in my view, the protection of consumers in tremendously difficult circumstances, through court support as well, relying on that statute. You've also had Bermuda with the Digital Asset Business Act, so DABA. You've had Cayman with the VASP Act. And all of these really came into being, as we know, 2018 in the case of Bermuda, 2020 in the Bahamas, and in Cayman 2020, somewhat ahead of the game compared to other jurisdictions. Now, there is a downside to that. There is divergence throughout the region, unlike a unified approach as we've seen with MiCA in the EU. But nonetheless, let's give credit where credit's due. I think the region has been pioneering, and certainly my experience in the Virgin Islands, in particular, the British Virgin Islands, is that when it comes to alternative means of resolution, whether it be arbitration, for instance, truly leading the way. But of course, we don't hear about it because it's confidential. Now, I can't speak to any detail, but I can certainly say that I have seen firsthand disputes being resolved in that and other jurisdictions in cutting edge ways, deploying the technology as part of law tech, reg tech. And look, I completely take on board what Keir says, and I'm not a fan of heavy, cumbersome legislation. that thousands of pages doesn't help anyone, certainly doesn't help industry, and it doesn't afford certainty. But what I will say is we need to return to what I said from the outset. Industry needs to engage and be listened to, and we all have to play a part in that. And that's something I'm always trying to do. I'm always trying to get industry figures round those tables, rather than just us lawyers and the politicians who may or may not have ulterior motives. So yeah, I welcome everyone on this call and everyone on this panel to be part of that in future.
Thanks, Racheal. So Matt, Racheal again, and Erika, the landscape of asset recovery, Matt, where does the journey begin? And things like FTX, interactive exchanges. Could you describe the landscape? What's happening? What are the courts saying? What's the legislation saying?
To take it from the top, so I worked on a case in 2019 where a hospital fell victim to a hack. All their screens went black, and they were asked to pay for a key to release that data and provide access to it for the small sum at that point of 100 Bitcoin. An insurer paid that ransom, and it was our task to trace it. Back in the day when Chainalysis were providing witness statements, we worked with them and went to court in 2019 and asked the question of the court, can crypto assets be property? They're neither a thing that is tangible or a contractual right, for instance. So they didn't sort of fall neatly into any of the categories of property. And the reason that's important is because we asked for what's called a proprietary injunction, an injunction over specific property. So if we're trying to do that over crypto assets, how does that work? Now, we were very lucky because in 2019, only a few months before, there was a paper from the UK Jurisdictional Task Force which asked this question of the industry and said that despite it not falling into either of the categories that had been pre-established, that it should in its own right be considered property. We relied on that at court, and the judge confirmed that crypto assets were property at law, including Bitcoin, which is great, right? Now, at the time, no one cared apart from a few geeky barristers, and the judgment was probably never supposed to come out, but it did. And it set the starting place for digital asset recoveries and the wider use and adoption of crypto assets, digital assets, whatever you want to call them, in general. That is the starting place for the asset recovery industry at law, so to speak. But then where do we go, right? Because there's lots of different cases that happened afterwards. And though the chronology of those marry up entirely with the process in which you recover assets. So shortly after that case, and it's called AA Persons Unknown, you had Ion Science, which was about the location of the crypto assets and where they were when they were stolen, because we were trying to work out the initial questions. We had, let's have a look, I've got a list here in front of me of 20 of my favorite ones that Brian and I put together a while ago now. We had, let's have a look. We had Fetch AI, which was about including a bona fide purchaser on the basis that assets were received by an innocent party. We had questions over software developers. We had questions about service. There was a case about the service of proceedings via NFTs. Racheal worked on a case called Osborne, where it was the recovery of NFTs. And you can see the chronological journey. All the questions that you need in the asset recovery space were being answered to the point where we are now later on at a stage where there's a case called Buniem. I'm pretty sure I've pronounced it wrong, where we are at a stage whereby now people are getting default judgments against particular individuals or persons unknown, i.e. the end or the near end of the procedure. And the academic and legal question is can you get default judgment against particular individuals or persons unknown where they can or can't be served in a particular way? So in answer to your question, Brian, where are we with all of this? Is we are pretty much now, hopefully, at the end of the stages at law whereby uncertainty is being answered. We're actually one of the latest cases, the name escapes me, is about how to assess damages. Now, if we're assessing damages, and that means we're at the very end of, hopefully, our line of substantive questioning. I'm hoping that now there are particular pieces of legislation at law relating to the proceeds of crime. It allows police officers and certain members of the public to assist in recovery of crypto assets, wider powers than there were before. So I think we're moving in the right direction. We've dealt with a lot of the intricacies of case law. There's legislative powers to allow the conduct for police to seize assets. And we had, I think it was last year, the Law Commission's paper on digital assets, which sort of loops nicely round to that original case, AA Persons Unknown, which dealt with the fact that at law, they were looking to recommend a new category of property, i.e. digital objects. And I was asked this at a meeting, the other day, as to what is happening with all of this. And their answer, the Law Commission's, was, we will let case law determine what happens. So a very long-winded answer to your question. What's happening is we are pretty much getting towards the end of the substantive question asking. And I'm hoping that now we're in a position whereby, now those questions have been answered, that the process of recovering those assets is infinitely easier, and that it is easier to educate people by reference to these cases, that the process is something that is not only achievable, but actually happens often.
But Matt, before you proceed, what does this mean for decentralization? And I know the three of you as the asset recovery lawyers are answering this question, but I want to pose a question to Keir as well at this point. What's decentralization as a concept, as a dev, and how does this sit with decentralization in the real world? Because let's say in the line of cases you've mentioned, did you mention Tulip? Did you mention Tulip, the Tulip case?
No, I didn't.
So now the Tulip case was discontinued, and there were some serious issues that were supposed to be tried in trial, and it didn't get to trial because the claimant pulled out. So how do the cases sit alongside the purist theories of decentralization?
Right. Well, I mean, for starters, I'm pleased to hear that legally cryptocurrency and digital assets are now being recognized as property. That's the kind of thing that when you're not a lawyer, it seems obvious to you, right? That, but I can see that, you know, we have, well, intellectual property, we have physical objects, you know, so I, as a non-lawyer, I kind of think, well, you know, I have a sense that I own my Bitcoin. Well, why would there be a problem? But I guess the wheels of law have to turn slowly but steadily to clarify all this stuff. As for how this applies to decentralization, well, you do get people in the blockchain technology industries who are a bit, I don't know how to say it politely, extreme in their views. And they, one big discussion I have all the time is the code is law one, right? If someone deploys a smart contract and there is a bug in it that allows me to siphon the assets off, well, the code says I'm allowed to do it, therefore surely I'm allowed to do it. And my take on that is, well, no, that's not how human society works. That's kind of like saying I've put my stuff in a garage and I thought I'd locked it, but it turned out I hadn't, and therefore you feel you can come along and, you know, the garage door is law, I can open it and therefore I can take the stuff out. It doesn't, society doesn't work that way. But there are people in the blockchain industry who feel that, yeah, if the code says I can do it, then I'm allowed to do it. That's kind of where all this stuff came from, because you know, a lot of the original discussions about the technologies that are now being used in blockchain, particularly cryptography, started off with some people fairly radical views at the time. Some of those views have been we now agree on. For example, you know, you don't have to go far back to see people being prosecuted for writing software that allowed people to communicate securely without the government listening in. So, but it all boils down to agendas, really, there, doesn't it? I think that what you know, what Matt was talking about sounds great. That and I'm just, as I said, as a non-lawyer, I'm surprised that it needed doing, but now that he said that it's being done, I understand why it's being done, and I'm glad to hear it. So I don't think really it has much. It doesn't say much to decentralization. That it's that the from my perspective, the point of decentralization is to ensure that you have kind of redundancy backups so that you don't lose your ledger, and that there are certain transactions that I can undertake and nobody can stop me. So, I need to be able to transfer my Bitcoin if I so choose, and I can't be censored. And we have laws pertaining to things like free speech or property ownership for tangible property and stuff like that pertain to these kind of things too. It's not, in that sense, it's not nothing new. It's just that in blockchain, these rules are being imposed through code rather than through a court. But ultimately, you need to be able to look at the code and say, well, actually, that was a mistake, or maybe we need to curtail that. It's a trade-off, but at least it's shifted the balance away from more and more regulation and control. And so we're having some discussions about things that do kind of boil down to freedom of speech issues, I suppose. And of course, that means that we've opened a massive can of worms again, because these things are never simple.
Thanks, Keir. Racheal?
Yes, I think if we take decentralization as a concept, well, at its heart, if we divorce it from the technology, at its heart is having autonomy without third parties being able to curtail your ability to do something. And so in this sense, it's an ecosystem by which I'm not reliant on a bank to approve me a mortgage, or I'm not reliant upon, God forbid, lawyers to get involved with some form of escrow. It's again the same concept as smart contracting, a kind of a digital escrow of a transaction without the need for intermediaries. And so it's a vision for the future. I think it will play a huge role in the future. As I say, my time this year has been completely dominated by assisting clients at the stage of interoperability between AI, predominantly generative AI, Gen AI, and crypto assets, blockchain technology, both public and private permission blockchains, and smart contracting. It's the future, whether we like it or not, and I particularly like it. Whether the courts are embracing decentralization, yes, I can give two clear examples. So I was fortunate enough to appear for the claimant in De Lawyer and Persons Unknown in, goodness, was it 2022? How time flies. And in that case, we didn't have conventional means of serving papers on the other side. And so what in legal terms is referred to as service. It's how you get things going in litigation terms. And so what do we do? In the past, the dark and distant past, that would have been the end. Tell the client they can't pursue their misappropriated cryptocurrency. But sitting down with my experts, we all determined that no, that can't be so. How can we settle for that in the 21st century? We have a perfectly good means of service. We simply mint a non-fungible token, use that as a vehicle, because that truly, to my mind, is what an NFT is. It's a vehicle for conveying value. It's like a box that you put a present in. It's an asset in its own right, but it can also convey rights and obligations under a smart contract. And so in the same sense, you can mint a token that directs you to a unique reference link that in turn directs you to a document repository, which can be password protected or anonymized by order of the court. And by doing that, there's a certain sense of justice, because the very wallet that was used to perpetrate a fraud, we argued, was used to commence legal proceedings against that person in question or persons. Now, I'm so pleased to have played, again, a tiny part in what has been, I think, an embrace of decentralization by the courts of crypto assets as a vehicle for actually obtaining justice. So again, giving rights to consumers with AA, then we wouldn't have got there. So that's just but one example of how the courts can embrace decentralization. There's so many more. Look at arbitration, ArbTech. You've seen places throughout Europe. I've also seen South America embracing AI-based tribunals with blockchain technology to record on the ledger details of court cases. And so I could go on and on, but I won't bore you.
Thanks, Racheal. Now, Matt, Racheal, again, Erika, please. There's been the issue of the involvement of the exchanges. There have been a line of cases saying that the exchanges are the ones that are liable whenever something happens. like a hack or whatever happens, okay? And there's a new line of case. It's actually one case. I don't know whether there's something new beyond Pirazude, but Pirazude says that can't be the way it's done because it's akin to you suing the banks all the time. So what's your position regarding that? And then Racheal and Erika, if you could take us through the discussions of the FTX and Celsius, because you, the two of you were involved in those cases respectively.
There's been this sort of, you're right, Brian, there's been this sort of issue around whether these crypto exchanges owe a quince care duty of care, which is essentially that if they know that there is a fraudulent transaction, they shouldn't make that transaction. And my view is whether there should be a duty of care on these exchanges is potentially something academic, right? Because the ones that will comply with court orders and the ones that will get engaged, to some extent, don't need a duty of care. They'll just help you or at least follow court orders. And the ones that won't, right? So if you implement a formal duty of care for an exchange in a jurisdiction and they are not known to comply, creating a common law duty of care for them to do so isn't all of a sudden going to convince them to start complying with things. Now, my view of things is that it doesn't necessarily require a specific duty of care like a bank, bearing in mind we have hundreds of years of banking law that probably don't apply to crypto exchanges for a variety of different things, even though there are some parallels with, you know, fractional banking and all that sort of stuff that some of these exchanges are doing. And which the philosophy of blockchain, or at least Bitcoin, was supposed to avoid, to have intermediaries doing these things. My view of things is the best way to protect is via some of this tech. Now, there are companies that I know of that do transaction monitoring, for instance, and some of these crypto exchanges should be implementing these checks. In the same way, my dad yesterday almost fell victim to a scam via a big telecoms company. They pretended as though they set up, they pretended they were Vodafone and tried to send him a phone, and it was a scam. Immediately, his bank called him and said, this looks like a scam. Now, do we expect crypto exchanges to do the same? The way that they'd be able to do that is to have within transaction monitoring and tech to see that the money that's being withdrawn is associated with bad actors or specific clusters of addresses that are associated with bad actors. So I guess my first point, number one, is we should embrace technology to ensure that we help customers. Now, the other point, I suppose, is, well, a lot of the time, the crypto exchanges, when you have traced funds to them following a hack or a scam, they're not enormously helpful, or they're at least inconsistent in their behavior. And I've experienced both of those. My view of things is that over time, some of the larger exchanges have actually got quite a lot better and want to assist. Now, it's not as heavy-handed as I would like it to have been back in the day. My position is softened a little bit. But my sense of thing is that people and those big brands want to be seen to be doing the right thing. And again, a duty will not necessarily, a formal duty will not necessarily compel them any more than they are. So the last point I want to make on this is I do think that there should be a softer approach, a best practices guideline of some kind, not necessarily a formal consumer law piece of legislation or some sort of regulatory novel that we were talking about earlier with Mika, but at least some sort of signed guidelines that these crypto exchanges could at least say that they practice to give confidence to consumers. Now, whether that is, as I say, transaction monitoring, whether that's say that, you know, I think Coinbase were looking at doing this, that if you lost 20 grand that they would reimburse you or something. I think that was something that was floated a few years ago, but something to not only prevent fraud, but also if it does occur, take a positive action to ensure that individuals are assisted. Now, what we don't want to do is overburden these exchanges, and they receive millions of letters each day from people who may or may not have a good case. So there needs to be some sort of vetting. But if there is a sense of moral responsibility to assist at least the industry, then I think we will all be in a better place. And I do genuinely believe that a formal duty may be not only heavy-handed, but certainly won't compel the bad actors in our industry to do anything positive. They'll probably move away and continue operating in the dark.
Racheal? And Keniel, what's
Yeah,
the...
I completely concur. I agree with everything Matt just said. Oh, sorry, Brian. I didn't quite hear you there.
Racheal. You go on, Racheal. Sorry.
No, that's all right. So no, I completely agree. I would like to see a crypto consumer charter with minimum obligations, as Matt says, from a transparency and transactional review point of view, from a robust security measures point of view, compliance programs from an AML perspective, consumer education, literacy, regular audits, reporting. To be fair, the exchanges, and I've often been up against them in legal proceedings, but then again, I've often advised them since 2019. I've seen it from both sides, and I do not envy them. Put it this way, I would not want to be a general counsel in any of these exchanges. The immense pressure, as Matt said, of a very small minority of people are nefarious actors in this space. The vast majority simply want to deal in crypto assets and be left well alone, just get on with it. But as a result, the exchanges have fallen victim to being used as vehicle for frauds. The vast majority unknowingly, and the minority knowingly. And so it's discerning that. But no, I would like to see those minimum obligations. There is a difficulty in several fronts. So what concerns me is you look at the terms and conditions of some of these exchanges, and they change by the day, in some case by the hour. So trying to keep on top of it is a nigh impossible task. So, and we're lawyers, so, but what if I'm a user? What if I'm a consumer? And without speaking to specific cases, there are such key fundamental issues that I need to understand as a user of a centralized exchange. Say, for instance, do I exercise control over my assets, or are they offering a truly custodial service? Are my assets being segregated or pooled with others? What happens when something goes wrong? Is there someone I can speak to? For instance, is there a retention of title clause, which basically means that no matter what happens, including insolvency, one would hope, it's still mine and I can clearly identify it. And so many more questions, including where are they headquartered? What's their operational structure? Well, who am I actually dealing with? Or is it just a ghost? Where are they? What law applies? And so many questions. Now, if lawyers are struggling, as I say, God help consumers, because it is a nigh impossible task. Those times need to change. But as with any industry, it will, rightly or wrongly, become more centralized. Let's face it, we're on the brink of central bank digital currencies. That's as centralized as you can get. It's not decentralized anymore in any way, shape, or form. And so that is the way the industry, I'm afraid, will be going. And look, it's not what I want to see. I want to see an embrace of the technology by the industry growing in maturity, as Matt says, without the need for a dominant centralized force. But there are, as Keir rightly said, some mavericks in the industry, and I've certainly come across them without naming names, as I'm sure Matt has. And look, that the concept of code as law is something I've been vehemently against since day one, so much so when delivering a talk several years ago, I had someone heckling at me in the audience about, oh, you're undermining code as law, which point I said, well, hand me that mobile phone of yours, and I'm not giving it back to you until the end of this conference, because code is law. It's now mine. We're living in an absolute alternative universe where legal norms don't apply, and seemingly you don't have any rights to your property either, because I've just taken it from you. So no, I think stepping back again, we need to ascertain what's important here. The industry needs a voice. It needs to mature and work with industry, not simply impose standards on them. But likewise, the industry needs to look at itself and take a cold, hard look and improve upon failings of the past. And in that sense, it won't be Groundhog Day with the dawn of the internet and harms to consumers, with the dawn of centralized finance and harms for market participants and market abuse. So that's my hope, and I'm sure it will materialize.
Thank you, Racheal. Erika, do you want to touch on the Celsius and FTX crashes and lessons learned for the Caribbean region. Then we open up maybe 2-3 questions from the audience. Then we wrap it up because time is, yeah.
Yes, I am actually going to continue on in the line that Racheal just kind of started, and it does tie to FTX and a theme that I'm hearing over the course of this call, and that is the maturing of the industry. And it doesn't just apply to the law. It also applies to accounting. It applies to venture capital. It applies to the globalized movement of this property, right? So every part of this ecosystem has matured. And that, I think, very rightfully stated by Racheal, creates a centralization. And I'm not against it. I think that decentralization should be the key and should be sort of at the center of every conversation about blockchain. But look at what happened with FTX. Let's take this small, tiny little sliver. We've all heard exactly what happened here, but they go out to Sequoia and they say, if you want due diligence, you can't invest, right? And so Sequoia says, race to the bottom, fundraising. We don't really have much time. We've got to get in. We've got to get in now. They go to EY. EY says, we got this. We can take care of the auditing of this. They had no idea what they were doing. And now each of these players in this ecosystem is being sort of outed and stated, their vulnerable underbelly has been exposed. And people had, these questions like, how is it that a company like Ernst & Young or any of these consulting firms stepped in, received money, said that these things were okay, looked at these books and gave it the green light, and this continued to happen, right? And so what I see us kind of facing in the future here is there are some big things that the industry has learned from FTX and Celsius, but as we've all talked about, there continue to be some of these bad actors. So what is it that we really can do? And so for what I do, for example, working on the front lines, working with people who are starting these companies, I have a minimum standard. It sounds really silly, but I have what I call the AITR protocol, and it stands for the Adults in the Room protocol. And I refuse to work with companies who are not going to be interested in the conversation about these consumer charters or a conversation about regulatory and compliance. I just won't do it because I don't have the time and I don't have any really interest. I have an interest in building this ecosystem in a responsible manner. So if someone doesn't want to show their face on a Zoom call, I'm not going to work with them. If they're going to contact me via Telegram, I'm not going to work with them. But that also extends to if a client comes to me and says, I don't need a consumer charter, respectfully, these regulatory bodies look at what your actual message is. Do you have data security? Do you have compliance? Do you have a plan for how to educate your consumers about the product that you're offering? Are you actually offering the product that you say that you're offering, or are you offering something different? None of this is actually all that different from any other company that gets started. And that's what I really try to impress and what I encourage other people to impress upon these companies as they grow into mature companies that offer real products to real people in a new economy is you are still a company and you still have a consumer, and there needs to be a product market fit. And if there is a product market fit and you betray those customers, they will leave you. And all of those sort of basic tenets of economies still apply, and they apply no matter how radical you think your thinking is. And so I think that's really the takeaway here is that no one is above the law. And if code as law is not the edict that has proven to be the product market fit for this ecosystem, we still have laws that apply. You still have to abide by them. And examples like Celsius and FTX, where the CEOs of these companies are now either in prison or facing a federal indictment, these people will have to answer for the things they did. And whether you agree with it or not, we as a public created laws and ecosystems and continue to challenge those things through conversations like this. And the people who break those laws have to answer. And I think, whether or not the laws are fit to purpose today, we are having these conversations in a more increasing amount. And I encourage you to take a look, actually a wonderful state of crypto chart on A16 crypto, whether you agree with this or not. I think this is a really wonderful way to say that as much as people say we've moved beyond crypto, the innovation indicators are the highest they've ever been. The adoption indicators, active developers in these communities continue to be high. Interested developers continuing to be high. Verified smart contracts in 2024 are the highest they've ever been. So this industry is not going anywhere. In fact, more institutional sort of spaces are coming in. There's a lot of room for innovation, but we still have to mature equally in all of these different spaces if we want to create a system that people respect and a product market fit for people who actually want to build and use these products. So I think those are the biggest takeaways. And I hope that my final word on this is that blockchain combined with AI, I think that some of these centralized players are going to be able to field some of these thousands of conversations and complaints that people have when they submit them to these centralized players. So tech maturing in these other ecosystems actually, I think, will really be able to instill trust in blockchain and the ability for these centralized players to meet the needs of a high volume of people who are interested in using the product.
Thank you very much, Erika. Now, before we take the audience questions, could we just do a quick wrap up of takeaways? I do it kind of different. I do the takeaways first, and then I go into the questions, and then I just wrap it up totally. So, Keir, you want to start off with the with your takeaway for this?
I mean, I'm left sort of wondering, we have all this regulation for conventional finance, and I mean, I can just off the top of my head think of what if I say Deutsche Bank, JP Morgan Chase, Standard Chartered, right? Billions in fines because they didn't follow the rules. Are we really learning anything? I mean, it doesn't seem to work as an outsider, and now we're creating more regulation for crypto. Are we just missing the point, which is that we haven't fixed it for old stuff? Now we're seeing the same problems with the new stuff, and we're doing the same thing to try and fix the new stuff. I mean, I don't see how it's going to work. And in particular, I was just thinking, Erika, about you're mentioning FTX. Weren't they failing to meet standard laws about auditing and accounting? And you mentioned like Sequoia just going, here, have our money, and Young saying, yeah, it all looks great. I mean, the conventional systems don't work, right? The FTX could have been picked up ages ago if somebody just paid attention. Crypto regulation wouldn't have helped with that. So I'm sort of left with the feeling that, other than the fact I'm really happy to hear that crypto is property, thanks to Matt Green, where are we going? Are we even pointing the ship in the right direction? Or so that's a question I'd leave us all with.
Thanks, Keir. Keniel?
This has been a tough one, but I appreciate the many points we've taken here. But I was rereading the title again, Achieving Trust and Security in the Caribbean. I think that's what we need: trust, transparency, consistency, and probably a global approach to even make this work. But I have hope. But I agree, crypto is not going anywhere. We're at the dawn of it, so let's see where it takes us.
Thank you, Keniel. Matt?
Yeah, again, I think I started with this. I'm going to end on this exact same point. We've gone through now in the last several years a lot of the main questions relating to the status of crypto assets, how they're treated, and the process of getting them back. And we're now in a position more than ever that once you have fallen victim to a hack, a scam, any kind of fraud, and you want those assets back, there are now so many different options available for you, so many well-trodden routes, that actually people should have confidence in the process in as much as they would have confidence in any other legal process. So my general message is education for getting the word out that this is a real thing, and especially when you feel as though you don't know who's hacked you or scammed you, doesn't matter, we figured it out, and let's go and get your assets back.
Thanks, Matt. Erika?
I hear you, that regulation, at the end of the day, didn't work in those situations on its face. But I think that when we have an ecosystem where when someone steals from another person and they feel wronged, we can play that system out. And then we as human beings can look at that and say, fundamentally, we don't want to sanction this. That's an important part of the process. I don't think that regulation is meant to cover every single individual on the planet. It's just, it would not work that way. But my hope and my takeaway here is that with the maturation of this industry, that slowly we will learn the extent or boundaries of this technology, and hopefully in the future, if we can actually get this sort of system and a little bit clearer, start to outsource some of those human failures to these decentralized ecosystems, which, from what I understand, is part of the point, is to remove some of those human failures, because FTX didn't fail because regulation was a failure. It failed because people knew what was happening and they chose money over the right thing. And we incentivize that. And so if blockchain can encourage us to change our incentives in some way, we will trust and outsource our trust to this decentralized ecosystem, and thereby build a robust system that can meet the challenges that a highly technical civilization is faced with in these next 100 years.
Thanks, Erika. Marina?
So going back to what was discussed today, I think that looking into Europe, we are already in a post-crypto assets regulation era in a way. We're looking into how this regulation is going to be implemented. And I think that at least for anyone listening, anyone that wants to learn and see how this works, and again, mostly learning from mistakes, don't repeat our mistakes. If we have done any, it will be shown over the time. But I think do engage, reach out. Everyone is really happy to explain more if needed of what MiCA is and how it will regulate. And as you said before, MiCA is regulating the market. So whoever wants to interact with European Union citizens, they will need to comply no matter where they are incorporated. And I think it's going to be pretty important. We do have, again, the IOSCO recommendations for crypto assets regulation and DeFi as well. And I think that further future regulation in other jurisdictions will not be so different from what we have in MiCA right now. So I welcome everyone to reach out if, again, anyone has any questions about it.
Thank you very much, Marina. Racheal?
The question let's put it this way, the thought I want to leave on is this, that let's have hope and let's be enthusiastic here. I'm forever an enthusiast and optimistic, and I think if the courts of England and Wales, after hundreds of years of doing things arguably the same way, can embrace non-fungible tokens in court proceedings while we've got wigs and gowns on and all that jazz, there's hope for everyone. Regulation fails, it comes too late. Let's look at the evolution of the internet. That regulation, the Online Safety Act, for instance, in the UK, it should have come 20 years ago. Instead, there's been 20 years of harms. Financial regulation, we've had whole economies crumble. We've had mispractice. We've had whole infrastructures brought down. And why is that? Because those standards weren't set out clearly and in compliance with industry practices and in collaboration with them from the outset. So let's be hopeful, let's be optimistic, let's learn from our past mistakes, and let's go into the future in a brighter way. And again, I shout out to the Caribbean. I think you're often overlooked, and for shame, because I think there are some fantastic things happening, which, quite frankly, are at the cutting edge. So don't overlook the Caribbean.
Thanks, Racheal. Deld? Your mic is on mute.
It's nice to be told that, but it just feels different. It hits different on the ground. And I hope I didn't mislead anyone when I said that, we weren't ready. I just think, the direction that we're heading in, we need to have more foundation in terms of understanding exactly what we're regulating. I think regulation for the sake of regulation is garbage. It's garbage in, garbage out, really, like we said before. I think the laws already exist to govern crypto and crypto asset service providers. We have anti-theft laws. We have laws against fraud. We have laws for financial institutions. these things already exist. I think, we could definitely spend more quality time trying to figure out exactly what the asset is, whether it's a thing of its own, or if it's a currency, or it's a commodity, or it's or property. So I have to agree with Keir when he mentioned that we do actually have laws that we could have used for it, and watching the process, the expensive process, especially for some of our jurisdictions that are strapped in that area, go through to create that new legislation when we could simply just have broadened what we have in place already. But it is really, really, really exciting. I have a tech group that meets every last Friday of the month, and there's a healthy peer-to-peer ecosystem down here, and that is nice. But I would like to see some of the things that we put in place get tested, and that hasn't really been the case, except for some of these very big and ugly things. But yes, I'm excited for the future, and I'm really, really privileged to have been a part of this group. I just wanted to say this. And Brian, thank you so much for putting this on.
Thank you so much. There's a dog barking outside. I'm so sorry for that. If you guys can pick that on the mic anyway. So there's no questions from the audience, and because of time, we'll just have to call it a day, unless there's a very pressing question from a member of the audience. I think we can call it a day, and then you can connect with the panelists on LinkedIn, and if you have any other questions that need clarification, or just to pick up conversation with them, probably mentorship or anything, just reach out to them directly. Thank you very much for your time, and I will stop the recording there. And yeah.
Thank you, everybody.